You don't.
Hear ye, hear ye, hear ye. All persons having anything to do before the ground, the justices, the appeals court, now sitting at Boston, within the handle of the Commonwealth, draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open, and be seated.
Okay. Thank you very much, and good morning. I'm going to begin by introducing the panel. To my right is Justice William Meade. To my left is Justice Catherine Hand. And my name is Ariane Vuono. I see we're all ready for the first case. I'm just going to remind the people who are in the audience and are going to be arguing thereafter that each side has 15 minutes to present their argument. If you need less time, that's perfectly all right. But if you need more time, unfortunately, you will probably not receive it. And there is no rebuttal in the appeals court. So all of your arguments need to be made at the time that you first take the podium. Okay, so I'm going to begin with Commonwealth versus James Fiorentini and remind you both that this case is partially impounded. Case number 2024-0044. Good morning.
Good morning. May it please the court. Marina Moriarty on behalf of the Commonwealth.
Let's start again. Can you lean a little bit closer to the microphone by chance? Try again.
Good morning.
That's
I
good.
apologize for my voice. I've lost my voice.
We can see that, but if you stay close to the microphone, I'm sure we can hear you. Great.
Good morning, Your Honors. Marina Moriarty on behalf of the Commonwealth. The motion judge in this case erred in allowing the defendant's motion to dismiss where the evidence in the police report supports a finding of probable cause that the defendant committed the crime of annoying and accosting because the defendant coupled his sexual commentary to his students with persistent attempts to look down the victim's shirt while she was seated in his classroom.
Could I ask one question before you get underway? Is the Commonwealth's theory on appeal that the conduct at issue is the peering down the shirt and that the sexualized discussion that happened before is context for that?
Yes, Your Honor.
Okay, and was that different than what was argued in front of the trial judge?
I don't think so. I think it was the trial, the argument below was that it was a combination of the commentary and the actions that led to the disorderly and offensive condition. That the commentary provided, the commentary provided the sexually charged atmosphere, which otherwise might not have been present in the classroom. I would first like to point this court's attention to a case that was decided by another panel of this court just yesterday, Commonwealth v. Cadet, C-A-D-E-T. It was an unreported decision. The court held that, in that case, the court held that dismissal of the complaint for annoying and accosting was an error where the defendant approached and spoke to a 15-year-old girl on her way home from work. I would suggest that the facts in the Cadet case are much more akin to the facts in this case than the facts on which the motion judge relied in Commonwealth v. Ramirez.
Okay, so you're saying this is an unpublished decision that was issued just yesterday?
Correct.
Do you have the number for it? Or the case number?
I don't have it in
That's
my...
okay.
I do, thank you. It's 24-P-45.
Thank you.
Given my voice, Your Honors, I would be happy to rest on my brief. Unless this court has any specific questions, I'm happy to answer.
Is the judge just dismissed the complaint relative to victim 2, right?
Correct.
And the complaint involving victim 1 is still in play?
Correct, and has a trial date, Your Honor.
Okay, thank you.
The Commonwealth argued that the trial should be delayed, but as of this moment, it does have a trial date.
All right.
And
Any further questions, Justice Meade? Thank you very much.
thank you, Your Honors.
Good morning. May it please the court. My name is Steve Nyman. I represent Mr. Fiorentini. I represent him down below as well. There is a trial date set for victim number 1. I think it is the 10th or 12th of January.
Okay.
And
2020, yeah, okay.
2025,
Okay.
right. And we've been trying to get it to trial for some time now. We finally at least have a date set for that. It's the position of my client, it's not my position, that the judge acted properly in dismissing the count as to V2 in this particular case, that the complaint was not supported by probable cause, and that case should remain dismissed. As to, we really have addressed a couple of points that the government made. First of all, that the disorderly aspect of this did not create a physically offensive condition, and it was not threatening, which is required under the statute. And there was no probable cause to view the defendant's conduct as offensive in the context of where he was and what he was doing.
But the victim, Mr. Nyman, the victim told the police that she felt threatened and didn't feel comfortable even being alone with him in the classroom.
Well, she wasn't alone in the classroom with him, and the fact that she felt threatened really shouldn't drive the decision in this particular case. His actions, his words, the sexualized conduct was directed towards the entire class.
But he approached her repeatedly and stared down her blouse.
That's what she said, that he...
Well, that's all we have is the complaint. It's,
right. You have
a probable cause.
I understand. You have a complaint that does not mention anybody else in the class witnessing, seeing that, experiencing that, feeling uncomfortable with that.
And that'll be a fine topic for cross-examination.
Right. And I'm hoping that, again, that we just don't have to get there.
But why, I mean... Why isn't this immoral and indecent?
Well, there's more to it than that, Your Honor. There's more that has to be met in terms of, you have to have probable cause as to all four of the elements: knowingly engaging in an offensive or disorderly act, intending to direct that conduct at the victim. There's no indication that he intended to direct it at her. She believed that it was directed at her because of the way she perceived him to be looking. But keep in mind, this is a public school classroom. It's a philosophy classroom. So you infer, as the government did in its brief, that there are other people there and that the students are sitting. And that
well, you say that in your brief that it wasn't indecent or immoral because it was a philosophy class, but this wasn't some Aristotelian discussion of Nicomachean and sexual ethics, was it? It was him describing the sex acts and how he positions himself with his partner and his affinity for sodomizing her.
To provoke discussion.
It was provocative, all right.
Well, that's correct, but it's one person who. One person in the context of this particular case who personalized it. But it wasn't him personalizing it to victim number 2. It was her personalizing it to herself.
Well, if the looking down a particular person's shirt isn't personal, what is it?
Well, it was her perceiving that he was looking down her shirt. It was her discomfort with the subject matter, and she perceived when he was walking by and teaching that he was looking down her shirt. It doesn't mean that he was intending to look down her shirt. It doesn't mean he was intending for his conduct to target her, intending her to be in fear.
Is that... It would be fair to say, and I don't want to distill your argument to one point, unless you agree with me, but would it be fair to say that the main point that you emphasize is that the defendant did not create a condition that a reasonable person would feel as if they had imminent physical harm? That's
correct, and I think that's mentioned on page 9 of my brief. I think that's where we initiate that discussion. We get into a little bit more of the detail of that, and we talk about how it has to be personalized, and we compare what he's alleged to have done to other people where this court has said, no, that is not offensive conduct under the statute or disorderly. You look at the Ramirez case, and That, if you look at the facts, seems to be a lot more egregious. There was a person who was targeted and individualized. You look at the Sullivan case.
They were, in Ramirez, though, they were strangers right on the street.
Yes, no, that,
He didn't have the, the authoritarian position that this person, as a teacher, had over a student.
well, I think that it was probably more of an issue in the Ramirez case because he was it went on for more than a day. It wasn't just her coming out of the pool the one day, but then him sticking his head out of the window another day, offering to buy her candy. This was a lot more threatening than what happened in this particular case, and the court still found in Ramirez that was not disorderly conduct. Same thing in the Chu case. And the Chu case is, they didn't find the conduct disorderly, and that was the case where the individual put up all the vile material about his ex-girlfriend and put up, missing posters, elaborating on the various sexual acts that she had engaged in with him. And the court in that one said that's not offensive either under the statute. The difference there was that was threatening. They found that threatening, and that's why the verdict was allowed to stand. That's completely different from where we are in this particular case now. Just have to establish that one of the elements was did not meet the probable cause standard, and I believe that's what we're able to do here. The other cases seem to support our position on that as well. Keep in mind also, when I think Justice Meade, when you were talking about the victim number two's perceptions in the classroom, what's missing from the application is the distance between the defendant. That nothing is mentioned about that in the four corners, the distance relative to that person and other people in the class as to who he was looking at and what he was doing.
But I think Justice Hand mentioned this before, to put his sexual dialogue puts in context the act of staring down her shirt repeatedly 5 to 6 times per class.
Well, right. I mean, not
So
to
the
be
question
pedantic.
is, although the victim told the police that she felt threatened and uncomfortable, the question is whether a reasonable person, under those circumstances, a student in a classroom with a teacher peering down her blouse while having a sexual dialogue about his various predilections.
I think you're conflating the two. So not necessarily that the sexual discussions were simultaneous to the looking. These sexual discussions were going on in all of his classes, according to this individual, and she was uncomfortable.
But they weren't like fleeting comments. They were, I think she said they lasted sometimes for 20 minutes.
They lasted at times, my impression was, for the length of the class at some point.
Right.
But that is separate from him looking at...
But during that class, he's repeatedly going and looking down her blouse. Well, the entire class may be, as you tell us, be this entire sexualized discussion. That affects how a reasonable person would perceive things, does it not?
Well, it'd be difficult to argue with that, except I keep going back to my initial comment, or one of my initial comments was, but no one else in the class felt that. You would have had...
I mean, it only matters that victim 1 and victim 2. You can't say because someone else wasn't offended, it wasn't reasonable for her to be offended.
I'm pretty sure that victim number 1's was separate and distinct from this, and not as part of the same... I don't mean from a legal perspective, I mean from a factual perspective. So I don't think it happened, or alleged to have happened, in the same context.
No, I mean the allegations involving victim 1 are far worse.
Right. But that's
are they not contemporaneous with this?
Not contemporaneous in terms of the same...
Are they in the same classroom?
They are in the same class, but the impression that you get, if you look at the supplemental report, which was part of the application process, was that happened either when the two of them were just together or in the hallway. It was sort of unclear if you read those, so not necessarily in front of the entire class. as opposed to victim number 2, I think the impression you get, and it wasn't totally clear, was that this happened to her in the class. So there is a distinction there. I don't know if the court has any additional questions.
I'll let you know in 1 second. No,
Thank
here. No, thank you very much. We appreciate your arguments, even though yours was a little bit difficult to get through. We appreciate your being here and answering our questions. Thank you. Okay, our next case on the list is case number 2023-0785, Commonwealth versus FARIZA, ELAWAD. Good morning.
Morning. Your Honors, I'm sure you've read the papers. This is a case that I'm sure is going to, probably like the prior case, evoke strong feelings one way or the other. This case, however, is at its heart about a parent's right to discipline their children as they seem fit in the privacy of their own home. While you've read the facts, just briefly, some important facts that I'd like to draw the court's attention to. I mean, this is February 4th, 2019. Police arrive at the home of Miss ELAWAD. This is a home that she shares with her husband and her 4 children. They say that they're there for a wellness check. And that's all the evidence that was presented in the lower court, because there was no testimony as to what had occurred between the mother and child before they arrived.
Because that would have been hearsay.
Yes, because of the hearsay, because the child was not there. They didn't bring her in to testify, so there was no direct evidence about, and that will become important for the second part of my argument, but about what the discipline was and why she was giving the discipline. Miss ELAWAD and her husband and her family were raised in Jordan. They speak Arabic, Jordanian Arabic, a dialect that also becomes important on the second count, the resisting arrest. Here, what occurred is police arrived. She has no understanding or idea why they are there. She, in her culture, believed and truly believed and told the police multiple times, as a parent, I have the right to discipline my child as I see fit.
How does that affect the real question, which is whether or not the Commonwealth's evidence was sufficient to disprove that the force was unreasonable?
Well, because,
The force
Your
was
Honor, I mean,
reasonable.
twofold. One, there's the hearsay issue. They have to first, there's two things. I mean, in Massachusetts, you got to prove the force used was reasonable. It was related to a legitimate purpose for disciplining the child, and that the force used either caused substantial harm or could have caused substantial harm.
But the Commonwealth only needs to disprove one of those factors, correct?
They have to, they've got to disprove, it's a privilege, it's affirmative defense. Commonwealth has an obligation, has the burden to disprove them with regard to the
Again, you
first.
said them, only disprove one.
Yes. And I
I
was.
just want to make sure that we're clear on that. Am I correct on that?
I'm sorry?
The Commonwealth only has to disprove one of those factors.
Yes.
All right.
And I would say to your honor that they did not disprove any of them. With regard to the first, that the force used was reasonable in the circumstances. There's a difference of opinion between the two officers as to exactly what occurred here. And granted, it may have been shocking to them, but by all accounts, it's undisputed that this woman stood calmly in her doorstep and said to them from the moment that they arrived, I don't understand, I have done nothing wrong, I was disciplining my child.
We have to look at the evidence in the light most favorable to the Commonwealth, and the police already testified that she became enraged when the daughter told the police what happened.
Yes. And again, I think, Your Honor, that harkens back to her belief and her cultural belief that the reason that she is disciplining this child in the first place is that this is a personal family matter. We don't know exactly what the child told the officers at the door, but what we do know is, at least for the majority of the exchange between officers and this woman, she was just, for lack of other words, flabbergasted that they were there. She didn't understand. In her mind, her child was doing something inappropriate, culturally inappropriate, by bringing private things outside of the home. I'm sorry, I didn't mean to.
It's just none of that is relevant to what we have to decide.
Well, it is. It's one of the factors. Whether or not it was related to the purpose of promoting the welfare of the child, including punishing the child, that's one of the factors.
The child was not addressing the mother. The child was speaking to the police. And then the mother, unprovoked, with a closed fist, punches the 12-year-old girl in the face so hard it almost knocks her down. The police officer testified that it made such a hollow thud that it made him cringe, and he had never seen any woman hit anyone harder than he had just witnessed that day. Why is that reasonable?
I understand that this is a shocking and difficult case to argue from my perspective. However, and it may have been shocking for the officers standing there, in her mind, and again, we've got to go back, and I've cited both Packer and Dorville in my memorandum. In Packer, there's a striking of the child with a fist on the ear. It causes bleeding. It causes a cut. It causes redness. They said that's not enough. Dorville says it's got to be more than fleeting pain or minor transient marks. In this case, it caused redness on her face. There is no injury. There's been no evidence of injury. The other officer who was there says, well, yes, it may have been a slap. She steadfastly maintained she slapped her child on the face. The child was not injured.
Is physical injury a requirement?
Physical injury is not a requirement. It's got to be something that would likely bring up on substantial harm to the child. In her mind, again, in her mind, she's disciplining the child. And again, there's an exchange that's going on between the officers, and I believe that...
I completely believe she thought she was disciplining the child, but even the husband testified that punching the little girl in the face was not reasonable.
And again, that's taking under context what he did say also, and if you look at his testimony, is he gave great detail about his understanding of his wife's right to discipline their child, including to hit the child.
But not to do what had happened.
Not to do what was alleged.
You've said I've taken it out of context, but the jury's allowed to pick and choose what they want to believe.
Sure.
And we have to look at that in the light most favorable to the Commonwealth.
Sure.
So it was not out of context.
Well, yes, but taking what he says that he believes in their culture, and they were raised, that hitting their children to discipline them and teach them what is right and wrong. And this is a family that has 4 children who are all straight A students, too, in college.
But explain to me again why that's relevant here.
And again, it's because he truly believed that his wife had done...
I understand what he believes and what she believed and what they thought that their rights were. But that, as you said in the very beginning of your argument, conflicts with the law of the Commonwealth, right? So how does that change things? I mean, it was a good argument to the jury. The jury wasn't persuaded, but it was an argument that was made to the jury that they should look at this differently. But now we're in a different posture in the case. Sure. What do we do with that cultural understanding at this point?
Well, I mean, it's a cultural understanding, but I mean, it's the purpose of the Dorville statute in and of itself is to protect the fundamental interest of a parent to direct the discipline as they seem fit, so long as it's reasonable. And and in Blixt and in Dorville, they talk about the fact that includes the right to use moderate force in order to do so. And I would suggest to you that this slap...
has a question.
Attorney Arter, is there any case that says that striking a child in the face with a closed fist is reasonable?
Well, there is the Packer case, Your Honor, where they do talk about the striking of the side of the face, and in that case, there was actually an injury. There was a laceration to the ear, there was bleeding, there was redness to the side of the face, and the court said even that is not enough because the slapping of the side of the face where it hit the ear, it injured the ear, again, goes back to Dorville. It's got to be more than fleeting pain or transient marks. And again, in this case, while it was shocking and the officer describes it as closed fist, although one says slap, there was some redness on her face, which by definition would be a transient mark. There was no other injury, and it was a small woman standing at the door who was very calm. There was no anger involved. There was no violence involved.
Does that matter? Does the anger or violence matter after Dorval? Doesn't Dorval reject that as a factor?
One of the things to be considered, and I believe both Dorval and Packard do talk about the fact that in the context of how it occurred, one, the context being the justification for doing it in her mind, and two, the context of was it part of an angry outburst, some sort of hostility towards the child, some intentional. In this case, we may not like what occurred, but it was a single sample. She was standing side by side by the girl, didn't move towards her, didn't lunge towards her. All of the evidence, and it's undisputed, she just stood there, was talking to the police, said, I have a right to do this. This is my right as a parent. I have a right to strike my child or to hit them in order to discipline them. And it may be unpleasant, but I would suggest that the Commonwealth did not disprove that it was for the purpose in her mind of disciplining, and that's the more, one that there's a little more leeway, and that the force was reasonable. It was not intended to harm the child. It was intended to show that she, as a parent, has the exclusive right to discipline her child.
Do you want to address the second conviction at all before you?
Absolutely, yes. With regard to the resisting arrest charge, again, I think, as I mentioned earlier, part of it is a cultural thing, part of it may be a language thing. All of this was brought forth before the court. It is undisputed, and every officer said that from the moment they got there up until the time that they placed her under arrest, she did not understand what they were doing. She just couldn't fathom that they were there because of something that happened in the privacy of her home.
But where was there evidence of that she could not fathom what was going on?
Well, I mean, it was through the police officers, because they said at every single moment she says, I don't understand, and they testified to this.
Well, she didn't understand why she couldn't discipline her child, but so
likewise,
so you're inferring, are you not, that there was an inference that she didn't understand what was going on, period?
That she didn't understand why they were there or had the right to be there. And part and parcel of resisting arrest is that you know and understand that you're being placed under arrest for a crime. And I would argue...
Well, you don't disagree that they told her, we're going to place you under arrest.
And the exchange between the time where they explained to her while she is saying, I don't understand, and starts to get upset, to the time where they place her in cuffs, and this is a small woman, is arguably 30 seconds.
Do you mean she's short?
I believe I meant slight. She's a woman. There's 3 officers standing around her.
Not to be indelicate, but the Commonwealth's brief describes her differently.
It describes her as larger than the child, and that I would grant it.
The police officers arrive for a well-being check in a marked cruiser and in a uniform, and they tell her that she's under arrest after she punches the child in the face. And why wouldn't a reasonable person in those circumstances know they are under arrest, since she was just told she's being placed under arrest?
Well, when the officers arrive, the discussion and the continued discussion throughout the exchange is, I don't understand why what I am doing to my child in the privacy of my home would give you the right to even be here.
You don't get to resist an unlawful arrest.
And again, with regard to the physical resisting, and this is a 30-second exchange between them where she is pulling away. She doesn't use any force or create any kind of risk to the officer. She doesn't go towards them. She says, I don't understand. She backs up. She pulls her arms down.
Excuse me. Her arms are flailing around. It takes 2 of them to put handcuffs on her. In fact, they require 2 pair of handcuffs to subdue her, and she uses her weight to leverage them to the ground.
Okay. Your Honor, I would suggest that this exchange, this 30-second to arguably 1-minute exchange before they put her in the cruiser, was her saying, I don't understand, her pulling away. It's the pulling away, it's the process of pulling away.
But effectuating arrest is not a snapshot in time. It's a process that begins at where they tell her under arrest, and it ends when she's placed in the cruiser. So any acts of resistance in that time frame are all relevant.
I understand the argument, and respectfully, I would say that she did not use any force towards the officer. She quite simply was continuing her statement to them that she did not understand. Understanding that you're being placed under arrest and understanding.
Did she pull them to the ground?
Looking at the evidence in a light most favorable to the Commonwealth as they were putting the handcuffs on her during that 30-second exchange, they put her to the ground.
Did she accept that she was under arrest and presented her arms for the handcuffing?
I believe that they took her arms and handcuffed her.
They were flailing.
And she was removed. She was backing away from officers. So my argument with regard to the resisting is a matter of degree, that resisting arrest requires that she understands she's being placed under arrest and then uses some degree of force to resist. And I would defer to my written argument on that, but I would say that with regard to the first count, that she's entitled to discipline her child as she sees fit in her home, and that the force that she used was reasonable, did not cause more than fleeting pain or transient marks, and she was entitled to do so. Unless you have anything else, I would defer to my memorandum.
No further questions. Thank you very
you.
much.
Good morning, Your Honors. Brandon Hunt for the Commonwealth, and may it please the Court. The issue was properly before the jury in this case, and the Commonwealth did disprove at least one, and I will argue all of the elements of the affirmative defense, the parental privilege. Here, the defendant's use of force against her daughter far exceeded what is reasonable physical discipline. It was neither measured nor limited, and it exceeded far beyond the scope of what's considered permissible under the parental privilege defense. I think the severity of the punch, that the victim lost her balance, nearly fell, and that it poses a substantial risk of serious bodily injury just inherent in the punch to the face from a full-grown adult to a 12-year-old daughter. Moving on to the, actually I wanted to address one of the points that the counsel has made concerning Packer. Packer, it was properly before the jury as well. In that situation, the parental privilege defense in that case was given as a jury instruction. The jury considered it and found that and acquitted the defendant in that case, and the appeal was based on the co-defendant not being able to use that parental privilege defense as a step-parent. And then moving on to the second issue, resisting arrest.
But before you get there, I have a question. Understanding, of course, the Commonwealth only needs to disprove one of these factors, as I said earlier. What do you say with respect to the issue of whether the force was reasonably related to a purpose of safeguarding the welfare of the child, since we don't really know what the wellness check was all about?
That wasn't developed because of the hearsay issue in the trial. However, we can see through the facts of the case that the parent, the mother, the daughter, the three officers were standing on the driveway. The situation was relatively calm. The daughter was explaining her feelings. The officers testified that she was relaying her feelings to them. One officer testified that...
No, I know the facts, but do you think it's a reasonable inference from those facts that that second factor would have been met beyond a reasonable doubt? Even though we don't know what the jury didn't know. I mean, we know now because we've read the sentencing hearing, but the jury didn't know what the wellness check was all about.
I would argue that...
There was really no evidence of what was going on there. You agree with me with that, right? The jury wouldn't have known. Okay.
Correct. The jury was not aware of why the officers were present at the time. However, the jury is free, and I would argue that they looked at this situation, they looked at the facts, and they concluded that there's no reasonable connection between the discipline and promoting the child's welfare.
At that moment, in other words. Right.
When the punch occurred.
And you think that's enough? And all you have to really worry about or be concerned about, a better way of putting it, is that moment, not what it was long term. I mean, for example, she was saying to the police, yes, I killed my best friend, or whatever, right? Then that might be a different situation.
I would push back a little bit respectfully
Okay.
on that, because I don't feel that a punch to a child's face, 12-year-old's face, contextually, in any event would be justified. Perhaps
In any event,
under
okay, there's
competing-
no way that would be related to the purpose of safeguarding. Okay.
Exactly.
I see your point. All right.
Now, on the resisting arrest charge, the counsel makes a lot of discussion about the defendant understanding the situation. I believe that perhaps the defendant didn't fully grasp the language barrier could have presented a challenge. However, the defendant did exclaim to the officers several times that after the punch had occurred, that I can do that, I can discipline my child just like that, I can do that again. And I think the jury could properly infer from that. She understood that perhaps something wrong in the eyes of the law occurred, and that the officers then, when they proceeded to say, "You're under arrest," and she began flailing her arms, you could infer that she understood that she was under arrest at that point.
Okay. The only element that I would like you to amplify a little bit is whether or not she created a substantial risk of causing bodily injury to the police. I guess that would be with the substantial risk would be with the flailing of the arms and then bringing them to the ground.
I read that, so under Chapter 268, I read that as an and/or, so using knowingly prevents or attempts to prevent a police officer from effectuating arrest by using, threatening, or the use of physical force or violence against a police officer or
There
another.
wasn't evidence of a threat, was there?
Or, no, there was no evidence of a threat, but she was using physical force to prevent that arrest from occurring. Okay. Or using any other means which creates a substantial risk of causing bodily injury to such police officer. So
For you, the flailing would justify, would be evidence of physical force?
The physical force, correct. And then also bringing the officers to the ground, leveraging her body to fall to the ground. They needed 2 handcuffs to secure her.
All right. Thank you.
If there are no further questions.
No further questions. Thank you both very much.
Thank you.
Third case on the list today is Commonwealth versus Jeffrey Hanson. This case is also partially impounded, 2024-0030.
Good morning. Michelle Dane for Jeffrey Hanson. May it please the court.
Morning.
I will begin by discussing issue 3 in my brief, discussing the testimony about Mr. Hanson's drug use. This was the subject of a motion in limine, and the Commonwealth agreed to not bring this evidence out in its case in chief, but they did express some concerns that Mr. Hanson might open the door through cross-examination of the various witnesses. The judge endorsed...
Excuse me,
Yes.
do you agree that this is analyzed under substantial risk?
I suggest that it is preserved error, but either way, I think that the evidence created a substantial risk of a miscarriage of justice, even if the court finds that it was not preserved.
Well, did the judge rule on the motion in limine?
The judge actually endorsed the motion as allowed, and he asked the prosecutor to go sidebar if he thought that the door had been open and he wanted to pursue that line of questioning. That isn't what happened, and the prosecutor instead asked Mr. Hanson's brother about why the two had drifted apart over the years, and that resulted in the brother saying that Mr. Hanson had a drug problem and he did not want that around his kids. The prosecutor also elicited by directly asking Mr. Hanson when he testified about whether or not he had a drug problem, and then this led to whether or not his use of drugs caused memory issues. And I guess the prosecutor was trying to lay the foundation that if Mr. Hanson was using drugs during the time frame of the abuse, that perhaps his recollection of that event was not as accurate. I would argue that the notion that someone would be so high that they would completely forget repeatedly sexually assaulting someone isn't really plausible, but regardless, the prosecutor should have gone sidebar to tell the judge that he wanted to pursue that line of questioning. And it's possible that the judge would have said, okay, we'll see if you can lay the foundation, but we'll do it outside the presence of the jury and do a voir dire of Mr. Hanson, so that way they're not exposed unnecessarily to this irrelevant and prejudicial information.
As to that particular point, though, there was no objection, correct? There was no objection to the failure to go to sidebar or a request to further explore that point.
There was not. There was no objection to go sidebar.
There's also no request, excuse me, no request for a curative. In fact, the defense counsel tell the judge that he or she was fine with how it is.
Right, there was no request for a jury instruction addressing this. It's possible that the attorney did not want to highlight the evidence.
When the defendant actually testifies, and correct me if I have it wrong, but he says, I was clean by this time, and so I have no memory problems. None of my prior drug use affects what I remember about anything.
Correct, and that's why it makes the testimony irrelevant. However, the jury was...
Well, the prosecutor didn't get the answer that he'd hoped for, but that doesn't make it irrelevant. Cross-examination is always fertile ground on cross to ask about someone's ability to perceive, is it not?
But again, the notion that someone would be so high that they would completely forget repeatedly sexually assaulting someone, that doesn't seem plausible to me.
Well, I mean, that would be a great jury argument, though, wouldn't it?
Again, if the prosecutor had gone sidebar, as he was instructed to do, the judge would have been appropriate for him to say, we can do this voir dire outside the presence of the jury, but until I know that he's actually going to say that he was using drugs at the time, I'm not going to let that type of testimony go in front of the jury. Because even though it wasn't able to...
I'm sorry to interrupt again, but I'm with you. The prosecutor should have gone to sidebar, because that's what he said to the judge. But tell me where the prejudice is.
The prejudice is that the jury was exposed to hearing that Mr. Hanson was a drug addict, that he had problems with pills and cocaine prior.
Not at any relevant time,
Not at the relevant time, but there was still character evidence, and it painted him as a drug addict, someone whose drug abuse was so bad that it impaired his relationship with his brother, and to the point where his brother didn't even want him around his kids because of his drug use. And so I think that it painted him as a drug addict, and in this type of case where Mr. Hanson testified and put his credibility on the line, and it was his credibility versus the credibility of the Commonwealth's witnesses, this was an attack on his character that would have diminished not only his credibility but his likability in the eyes of the jury.
You think that would eclipse the allegation itself, what the eyes of the jury would be?
I'm sorry, what was that?
His prior drug use was not eclipsed by the charges he was then facing?
Well, his prior drug use had no relevance as to whether or not he actually committed the acts that he was accused of, but that's exactly what the jury could have used it as based on how the testimony came in. And
as far as the brother, do you not agree that he opened the door in his testimony? The defense counsel opened the door with his question.
By asking the brother about the closeness of their relationship?
Yes.
The relationship of the two brothers was relevant because, again, his brother's credibility was at issue because he was saying that Mr. Hanson made admissions to him. So how close they were was relevant, but the reason for them no longer being close had no probative value other than to show Mr. Hanson as a drug addict.
And that immediately garnered an objection.
There was no objection, but the issue was addressed in the motion in limine. The motion was endorsed as allowed by the judge.
Do we know, I'm sorry, do we know when the motion was endorsed?
It was the last hearing before.
Does the docket reflect that he acted on the motion?
If I could. I believe the motion is included as part of the record appendix, and the endorsement is on there with the date that it is allowed. But it was addressed at the final hearing before they started impaneling the jury, and that was the instructions that the judge gave to the prosecutor. But regardless whether...
I just want to clarify something. The motion in limine, even if it preserves anything, would only preserve the brother's testimony, not the defendant's testimony.
I think the motion was to prohibit the Commonwealth from using or referring to bad acts involving Mr. Hanson, and that the Commonwealth refrain from offering evidence which purports to show that the defendant used drugs in the past.
And then, and leaving out the important part, when they discussed it with the judge, it was agreed that that would not occur in the Commonwealth's case in chief.
Right, they agreed not to bring it out, and the judge said, if you want to bring it out at any other point after.
My only question is that the defendant's testimony is not part of the Commonwealth's case in chief. Yes?
Right, and they agreed not to bring it out in the case in chief, and the judge said, if you want to bring it out at any time because you feel the defendant has opened the door,
You think
then
that,
come sidebar.
that comment extended it to the defendant's case?
Yes, I mean, to find that the motion that was filed was only applicable to the Commonwealth's witnesses would be illogical. It was clear that he was trying to keep out this evidence from the jury, from the jury hearing it, regardless of who was testifying.
When they had the discussion and the prosecutor's agreement, did defense counsel make the point that you're making to us that if he's going to bring it out at any time in the entire case?
I think, again, the only agreement was that the prosecutor would not elicit it in his case in chief, and that if he was going to bring it up at any point, my reading of it, that he would have to go sidebar, and that it wasn't done. And the way I read the motion is that this testimony was not to be, that the defendant was trying to keep this testimony out regardless of who was testifying, and then it was endorsed as allowed with a caveat that if the prosecutor wished to go into this line of questioning, that he come sidebar and tell the judge, why he wanted to get into that. But I do think that whether or not the issue was actually preserved, that there was a substantial risk of a miscarriage of justice which occurred. Evidence of a person's character might lead a jury to conclude that a person acted in a particular way simply because his character suggests he would, and it may also lead a jury to return a guilty verdict based on their dislike of the person rather than based on the facts before them. So that is the concern that we have here, even without a limiting instruction, and even without objections being made during trial at the time of this questioning, that there is every chance that the jury would have viewed Mr. Hanson as a drug addict and would have looked down on him, especially when he was testifying. Now, the prosecutor did not specifically mention Mr. Hanson's drug use during the closing argument, but indirectly by saying that it's the quality of the witnesses that the jury should consider and not the quantity. I think the inference can be made that the quality of the one witness that Mr. Hanson put on himself was that of a drug addict rather than the quality of the Commonwealth.
Why wasn't that a reference to the mother and fresh complaint witness's testimony and the victim herself, who is now 9 at the time of trial?
And if I can segue kind of into my second argument, which was...
that was actually a question.
Well, it could have been, and I think that was problematic regardless of what he was referring to, by saying that the jury should... First of all, he described the testimony as being gut-wrenching testimony. And so he's talking about the testimony of the mother, the testimony of the brother, and the testimony of the child herself, and then making arguments that all of these witnesses should be believed because of the burden it took for them to come in.
And didn't both the prosecutor and defense counsel refer to the testimony as gut-wrenching?
Yes, sorry, the defense counsel did refer to it as gut-wrenching.
Why isn't that clearly, or when the prosecutor talks about the quality of evidence, the fact that he has a victim giving gut-wrenching testimony, why isn't that a reference to the quality of the evidence that they heard?
Again, the defense counsel described the testimony as gut-wrenching to remind the jury to put their emotions aside and to review the evidence dispassionately and critically. He wasn't saying that was a reason that the witnesses should be believed. I would also suggest that the prosecutor, by implied that they should believe the child because it wasn't easy for her to testify because she was 9 years old and having to talk about some terrible things that happened to her.
The defense brought that out.
No, that was in the prosecutor's
Yeah, well, the defense brought out the evidence
closing argument.
that it was hard for her. The prosecutor used it.
But he also made similar arguments in regards to his brother, saying that it was hard for him to have to testify against his own flesh and blood. Same thing for the mother, that she was having to talk about a private and intimate disclosure. And the case law is clear that prosecutors cannot imply that their witnesses should be believed simply because they came in and took...
But prosecutors can argue, based on circumstances and demeanor, why a witness should be believed, such as it was hard for them and it was gut-wrenching testimony. The prosecutor at no point argued, and correct me again if I'm wrong, that you should believe, she had the guts to come here and testify today and you should believe her.
By the arguments he made, he was indirectly arguing that.
Okay.
If I can quickly address the last issue in my brief, discussing the mother's part of her first complaint testimony. The court has said that a jury does not need to know how a complaint of sexual abuse evolves into the case before them, and the fact that the Commonwealth brought its resources to bear on the incident creates an imprimatur of official belief in the complainant. Here, the jury heard about several steps that the mother took after after the sexual abuse was disclosed to her. She stated that she contacted the pediatrician, that she went to the pediatrician's office and met with a social worker, that the social worker assisted her in calling DCF, and then she reported it to the police. And these are similar crisis intervention steps that the court found to be inappropriate in Commonwealth versus Haggett, where a counselor was allowed to testify that she told the child's parents, filed a 51A, and assisted in reporting to the police. And the court said that...
Can you remind me whether in the case that you're citing to, the argument was that the parent had engineered the child's entire testimony and account?
I don't believe that was the argument there.
Which is the case here, correct?
It was part of the argument that was raised is that the mother had put the child up to making these allegations based on, their contentious...
The fact that she hated the father.
Correct. But I don't think that argument makes all of these actions that the mother took to be irrelevant or not. If the mother was fabricating these allegations, it was being truthful. These are steps that she would have taken anyways to try to...
Why wouldn't she have gone straight to the police? Why isn't there an argument to say that if she wanted to completely drop a ton of bricks on the father, she would have taken her allegations, gone straight to the police, not taken any of the intervening steps, not done any of the assessing of what other steps she could take, but gone straight to the source?
So I think it's anything, these are steps that any mother would take, regardless of if the allegations were true or not. If there are no further questions, I'm almost out of time, so I'll rest on my brief.
Thank you very much. Commonwealth?
Good morning, and may it please the court, Jesse Paul Crane for the Commonwealth, asking that you affirm the defendant's convictions. I want to just first acknowledge the presence of the victim's mother here today. And I will also start by addressing the defendant's drug use. The motion in limine was limited to the defendant, to the Commonwealth's case in chief. So the cross-examination of the defendant was not encompassed by the motion in limine.
Can you bring that microphone closer to Mr. Crane?
Yeah, I apologize.
Why didn't the prosecutor go to sidebar?
He wasn't required to in this case. That was only if the Commonwealth believed on cross-examination of the Commonwealth's witnesses that the defendant had opened the door. The concern was, I believe specifically, that the mother's testimony might open the door to the defendant's drug use.
But the brothers did.
I think in that case, yes, it did.
But the prosecutor didn't go to the sidebar, though.
I believe in the context that this was not, the prosecutor wasn't attempting to solicit that particular response. I think...
What response what could have been intended?
He was...
Asking to explain why there was a drifting of apart.
I believe he was trying to solicit the first part of the brother's answer, which was that it was this case that had really driven a wedge between them. And so in that instance, a single fleeting reference to the defendant's drug use, I would argue, does not create either a prejudicial error or a substantial risk of a miscarriage of justice.
Well, Ms. Dame tells us that the judge allowed the motion in limine.
Yes, he did.
He did? Oh, I misunderstood your 16L letter.
My 16L letter was to say that because the judge had heard and allowed the motion in limine, that was not sufficient to preserve the appellate issue, because under Grady, the entire rationale for not requiring trial counsel to make the objection is to not make a futile objection.
Right.
In this case, the defendant could have objected and almost certainly would have gotten a...
So anything that was in the motion in limine is preserved, and the other things the defendant's testimony is not preserved?
I would argue nothing is preserved because the motion in limine was allowed.
Now I'm lost.
Nothing was preserved because the motion in limine was allowed.
Because Grady
Isn't it
requires...
just the opposite?
Grady requires that the motion in limine be heard and denied under the rationale that the trial judge have the opportunity to hear the argument and then either allow or deny it. The defendant, to preserve his appellate rights, needs to object again, is my argument.
Is that what Grady says? In fact, I thought Grady was trying to remove all of that complications by saying if it's an allowed motion in limine, then it's preserved and you don't have to object again.
Yes, if it's heard and denied, is the language in Grady. I think, to be quite frank, though, at least in the issue of the brother's testimony, it's not, because it's a single fleeting reference, regardless of whether it's preserved or not, it was not prejudicial to the defendant.
Okay.
And just to flesh that out a little bit further, the defendant's testimony was fairly minimal in terms of what his drug use was during the relevant period of the abuse. He largely did deny having memory problems. He largely denied having a drug problem beyond occasionally using marijuana. And there were actions taken by the trial judge to limit any potential prejudice. The prosecutor, I think, was clearly attempting to impeach the defendant's memory and perception, and the trial judge did attempt to cabin that line of questioning to the relevant period rather than the entire span of the defendant's drug use. And then finally, there was, of course, the issue of the jury instructions, where the trial judge gave an instruction saying that the jury should not find the defendant guilty on any other bad act, or just because they believe that the defendant did something that they believed was improper. I'll turn to the mother's testimony. In this instance, that was admissible as both first complaint testimony and to rebut the defense theory of fabrication. The defense was that the mother had essentially orchestrated the entire complaint, and either the victim had never said something or had sort of said something but it was misinterpreted. The mother's actions post-complaint were very relevant then to the victim's suggestibility, and also to the mother's credibility in terms of whether she was making this report because she hated the defendant or because, as the Commonwealth argued, that the victim had made a complaint.
How is that part of first complaint testimony, the mother's subsequent actions?
Under King, the first complaint witness can testify to the relevant conditions that might help a jury assess the veracity of the complainant's allegations or assess specific defense theories. So in this case, because the argument was suggestibility or fabrication by the mother, it was relevant to the victim's credibility of what she had testified to on the stand.
Okay, thanks.
And then finally, I'll turn to the closing argument piece of this. I'll just say that many of these phrases were more comments on either testimony that had been elicited at trial or simply the prosecutor making a permissible argument that the Commonwealth's witnesses were more credible, which of course he was entitled to do in his closing argument. And I'll just end by noting that even if there was an error in terms of the closing arguments, the trial judge did instruct the jury twice that arguments were not evidence and that they shouldn't decide the case on prejudice or sympathy. If there are no further questions, I will rest on my brief.
Seeing none, thank you both very much.
Thank you.
All right, our next case is number 2024-0350. This case is impounded. Department of Children and Families versus Child and Another. Okay, and who are we missing then? Steve Rosenthal? Do you want to see if he's outside? Thank you.
That's why we have to get rid of the staggered start.
Yeah.
I've already discussed it.
Okay. Okay, good morning. All right, just for the record, I'll call the case again, 2024-0350, Department of Children and Families versus Child, and of course, all parties know that the case is impounded. And I understand that you're spilling your time, 12 minutes and 3 minutes?
That's correct.
Great, thank you.
Thank you, Your Honor. My apologies for being late. I didn't realize we were getting called early. Stephen Rosenthal for the appellant mother. First of all, mother is asking that the termination order be vacated and the case remanded for a new trial. If this court is inclined to affirm the lower court judgment, then mother asks that the case be remanded for, in light of the child's recent change of position, be remanded to determine for further evidence as to whether the existing order is in the child's best interest. The existing order grants 2 visits a year with some discretion to the adoptive parents and some cards perhaps, but if I understand it correctly, child is asking for weekly sleepovers with mother, which indicates to me that despite having 1 or 2 visits since the trial ended, child is still deeply committed to her relationship with her mother. So I'll move on from there. First, I want to address the judge's decision on the motion to reopen the evidence. The judge has discretion to grant such a motion, but she didn't have the discretion to consider materials which violated Juvenile Court Rule 7B.
Could I ask a question, Attorney Rosenthal? Is there any evidence that the department was allowed to introduce after the stipulation that wasn't included in the stipulation?
I'm not sure I understand the
Did the
question,
stipulation
Your Honor.
cover all of the ground that you're disputing now?
I believe it wasn't until the trial took place in May and July of 2023 that the evidence of any further connection between mother and the person who I will refer to as Stephen only was presented. There was no evidentiary hearing on the motion to reopen the evidence. There was argument by the attorneys, but the affidavit, in quotes, the affidavit was presented, but it had no evidentiary value at that time because it didn't comply with the rule.
And it was not included, I'm sorry to ask this again, but just to be clear, but that report, I understand which one you're talking about, was not part of the stipulation.
In the stipulation, the parties agreed that that report, the one dated, I think it was November 23 of 2021, was admissible subject to motions in limine that the parties could bring at trial.
Okay. Thanks.
But my point is that would require this court to give validity to that report, which was not an affidavit, it was just a report, give validity to it nunc-pro-tunc, at the time of the motion to reopen the evidence.
And is that because your argument is that there would have been no stipulation if that motion had not been allowed?
If the motion hadn't been allowed, the judgment would have become final. Now, I think there's, just by way of example, I would compare this situation to one where a party tries to oppose a motion for summary judgment with an affidavit that's based solely on hearsay. In a situation like that, that type of affidavit can't be used. And similarly, the purported affidavit in this case can't be used to support the motion to reopen the evidence. DCF had an obligation, and certainly had the option, to appeal the judgment that issued on October 10, 2021, within 30 days. But I think there's a reasonable inference in this case that DCF made a tactical decision to avoid filing an appeal. They could have filed a motion to file their appeal late.
But could they have filed an appeal based on newly discovered evidence?
Well,
or am I misunderstanding?
They could have filed a 6B motion, 6B2 motion,
Okay.
asking to have the judgment amended or have a new trial on the basis of newly discovered evidence, but that doesn't toll the 30-day appeal period. They still would have had to file the notice of appeal before November 18, 2021. Now, if they had filed a notice of appeal, then the judge would have had to issue findings in support of the decision granting custody to the mother. And DCF would be required to show good cause for filing a notice of appeal late. So my position is that they did an end run. In other words, rather than face the prospect of having the judge, after the best interest trial, issue findings of fact, which she would have had to do if there was a notice of appeal filed, they found another way to get a second bite at the apple. And the problem here is that you'll notice by looking at the original order for judgment dated October 18, 2021, that there's no mention there of that DCF had proven there was reasonable efforts made by DCF. In fact, if you look at the cross-examination of the ongoing social worker during the best interest trial, I think the judge would have been well within her authority to say that DCF had not met its burden to use reasonable efforts. And that's why, even though the judge said mother's unfit, that unfitness is going to continue, she granted custody to mother, granted on a conditional basis, but in spite of everything, in spite of the evidence that there was an involvement with what DCF considered inappropriate companions, she found in mother's favor. Okay. In any event, again, the companion named Stephen, the one who had a conviction, that conviction dated back to 1995. And the fact that DCF found him or considered him to be an inappropriate companion, and the fact that the judge eventually accepted that relationship as being an inappropriate relationship, overlooks the fact that for 26 years, from 1995 to 2021, there was no evidence of any violent or criminal activity on the part of this gentleman. His involvement with mother was irrelevant, essentially, to the issue of unfitness. If it were relevant, the judge would not have granted custody in the first place on October 18, 2021. I'd like to now address the issue of reasonable efforts. And I'll refer you back to pages 41 to 43 of Mother's principal brief. But in addition to all the things that were pointed out at that section of the brief that DCF failed to do in making reasonable efforts to reunite this family, the record shows that the ongoing social worker conducted no home visits with Mother from the month that child was removed in December of 2020 until July of 2021, after the abuse of discretion motion was heard. Highly inappropriate in this case. If you look at the cross-examination of the ongoing social worker in the best interest trial, it was one thing after another that he failed to do. Failed to document contacts that he made, failed to meet various deadlines that the policies of DCF require. Now, on March 24 of 2022, there was a stipulation as to unfitness. And that stipulation could be found in the record appendix at pages 101 to 105. But Mother did not stipulate to a finding that DCF had engaged in reasonable efforts. There were findings at record appendix page 108 that the judge filled out a one-page sheet. But those findings don't indicate what services DCF provided, only what Mother allegedly failed to do.
But isn't the failure to or isn't a lack of a challenge implicit in that stipulation? By stipulating, didn't the mother waive that argument, is what I'm asking.
Mother stipulated as to unfitness. She did not stipulate as to the issue of reasonable efforts. And the judge, when she made a finding of reasonable efforts, those findings were inadequate. They didn't say, the findings didn't say, here's what DCF did to reunite this family. They only said, here's what Mother didn't do. She wasn't honest, she was inconsistent, etc. Okay, those are not things that DCF has to do. They have to provide her with services. They didn't do that. I would also point out, my sisters here have argued that there was a waiver of that claim. But I would refer you to a case that came out just on October 18th of this year. It was a case that actually you were on the panel for, adoption of Oslo. And in that case, if I can find it, the court indicated, and it was a situation very much like this one, where the parent had stipulated to unfitness at some point. The department's obligation to use reasonable efforts towards reunification is ongoing even after the issuance of the redetermination decision. Therefore, the department has been and remains under a continuous obligation to make such efforts. And those efforts weren't made in this case.
Can I ask a question which isn't something that was briefed and I may be off the mark, but was the abuse of discretion motion even a proper abuse of discretion motion under Rashida? It seems to me that it was arguing the child's changed circumstances, not arguing for specific services. Am I mistaken about that?
I'm not sure how to answer that question.
It's
Could you
an
rephrase,
out-of-left-field
please?
question, so I'm not going to put you on the spot about it. And can you just tell me what were the services that the mother said that the department needed to provide that they didn't beyond a timely parent aid? Were there others?
Well, Your Honor, in my principal brief, under the disability policy of DCF, they had an obligation to do at least one of three things. One, to ask the mother if she could use reasonable accommodations. And given her mental health history and her other problems, that would certainly have been appropriate in this case. They also had an obligation, another option, was to consult with their superiors, and there was no evidence that there was any consultation to determine how do we deal with this woman. And lastly, and I can't read the entire list, but DCF employs a whole range of mental health specialists that can be consulted to determine the best way to service and to help the parent overcome the disability that everybody acknowledged in this case. I see that my time is up. Thank you for your time. I rest on my brief.
Thank you.
Thank you.
Yes, Your Honor. I'm Lois Farmer, and I represent the child, and she specifically asked me to tell you that she wants to see her mother every week, and she wants overnight visits. She even has a plan for it. I honor her request by informing you of that. What I had argued in my brief was that the visitation should be certainly increased because of the extraordinarily deep bond this child has with her mother. Now, the court's decision awarding mother the limited visits, I would suggest, is inconsistent with the judge's finding of the significant emotional relationship between the child and mother, how beneficial it is for the child, in the child's best interest to continue the relationship post-adoption. Where this child is deeply bonded with the mother, this case presents a challenge of how to support the child in maintaining that bond, which the judge stated is very important while being protective of the adoptive parental relationship. When determining whether the child should have visitation and how much, as the DCF argued in its brief, the goal is not to strengthen the parental bond. Conversely, is not to punish the parental bond. And I would suggest, not argue, but it's also the goal is to protect that parental relationship being undertaken by the adoptive family. However, there is that additional perspective that cannot be disregarded, that of the emotional impact on the child. Essentially, by severing the parental contact, limiting it to 4 hours a year.
But was this actually limited to that? Don't the adoptive parents have the authority to increase that?
The order does allow for the adoptive discretion in enlarging it, except that we don't have any evidence on which the judge could have concluded that the discretion would be actually honored by the adoptive parents. Would they be thinking in terms of the child? Would they be thinking in terms of how it affects this child not seeing the sole living biological parent that she has?
Isn't there a presumption that the adoptive parents will act in the child's best interest?
There's a presumption, but if you look at especially two cases, and that would be the case of John and Orrin, I think is, yes, John and Orrin, I'm sorry, which was decided by this court. Both of those cases were remanded to the trial court because there was no basis on which it could be determined whether or not these adoptive family will honor and live with that presumption. We don't know what the relationship was with this family, with the mother. We know that they had long ago been friends. We know that, thank
The
goodness,
mother supported the placement.
and the mother's in support of the placement. The family, the pre-adoptive family stepped up and did a wonderful thing by offering to take this child in. But we don't know how they're going to look at the discretion that they had. So I would suggest that you really need to look at that, and it was not dealt with at all in the trial.
Any further? More questions? No. I'm sorry, your time is up, and we appreciate your presentation, and you can rest on your
I'll
brief.
rest on my brief.
Thank
Thank
you.
you.
All right, Department.
Good morning, and may it please the court. Mackenzie Herbst for Appellee, Department of Children and Families. There was overwhelming evidence in this case that mother was unfit, that her unfitness was likely to continue into the indefinite future, and that termination of parental rights was in the best interest of the child. The trial court's decision should be affirmed for 3 reasons. First, the trial court's decision was careful, detailed, and well-founded. The trial court made 374 findings of fact and 24 pages of conclusions of law. Second, mother points to a tiny fraction of the trial court's factual findings to claim an error was made. But if you look at the entire record, much of which is undisputed, the evidence is overwhelming that mother's troubling decisions, behaviors, and relationships put child's physical and mental safety at severe risk. Third, even if mother's arguments regarding procedural errors were well-founded, which they are not, there was no violation of due process. Mother entered into a stipulation of judgment knowingly, voluntarily, and with advice of counsel after the alleged errors were made and waived her right to appeal.
What was the impact, if there was one, of the stipulation on the mother's abuse of discretion motion?
So with regards to the abuse of discretion motion, after the stipulation was entered, the judge entered a judgment against the mother, including finding reasonable efforts were made. The fact that the mother never re-raised any issues of reasonable efforts, including those that were in her abuse of discretion motion, means she waived it. The case law is clear that she has to raise the issue timely, and perhaps she did at first, but the fact that she never requested that a ruling be made on the abuse of discretion motion means she waived the issue. Mother doesn't raise any allegations of deficiencies in DCF's reasonable efforts after the stipulation. Everything that mother points to was before the stipulation in either the abuse of discretion motion or in the first best interest trial. And from what I can tell, the only service that mother is pointing to that she requested and wasn't given immediately was the parent aid. I'm not quite sure what other services she expected from DCF, but DCF did provide the parent aid eventually. Admittedly, it did take several months, but mother lost the parent aid services several months later because she failed to show up for the visits. She would cancel the visits, and she was hostile to the parent aid. I will offer that DCF, recommended that she see her therapist regularly, that she have her social worker conduct medication checks. DCF also connected her with her psychiatrist. So again, I'm not quite sure what other efforts mother thinks DCF should have made here, but it's clear based on this record that DCF did make reasonable efforts.
So is it your argument that those efforts that DCF made were enough to satisfy its own policy about its own disability policy?
Yes.
And that there didn't need to be any more inquiry about specific services mother might have needed, which if I understand correctly from Attorney Rosenthal's argument, would have included more mental health services or something on those lines?
Yes. Mother is correct that DCF's obligation is ongoing. DCF did meet with mother in June of 2021, and that's when she requested the parent aid again, and that's what led to her getting the parent aid. With regards of whether or not DCF should have been reaching out more after that date and after the stipulation, I think frankly doesn't matter because mother never re-raised the issue. And so DCF, if mother doesn't timely raise the issue, DCF is not able to fix the inadequacy.
But in this particular instance, if I'm understanding correctly, the policy requires DCF to be the proactive party there, not the mother. So is DCF excused from the obligation its own policy imposes if the mother doesn't raise it?
No, of course not. And I would say on this record, DCF did continue to meet its obligation and meet its own policy. She had frequent visits with her social worker checking in on her, and she continued to meet with her psychiatrist and her therapist. But the record also shows that even when mother utilized these services, which was inconsistent, even when she utilized these services, she failed to utilize them meaningfully. She was not forthcoming with her therapist, which severely hindered his ability to help her. She was not forthcoming with DCF or her social worker, which again inhibited their ability to help her.
Thank you.
I'll turn next to the motion to reopen evidence. Mother waived her right to appeal that decision to reopen evidence. After the trial court granted DCF's motion to reopen, Mother submitted a stipulation to judgment in which Mother stipulated to her unfitness, agreed that child was in need of care and protection and would be committed to the permanent custody of DCF, agreed to deem DCF's new evidence admitted, including the court report dated November 23rd, 2021, that was the basis for the motion to reopen. And that was number 60, Exhibit 68, Record Appendix, at Record Appendix 104. And lastly, Mother waived any and all rights to appeal this matter. There is no dispute that Mother entered into this stipulation expressly, knowingly, and voluntarily. Mother confirmed this herself under oath. Mother made the strategic decision to enter into this stipulation of judgment. She did so with the advice of counsel, and nothing about the stipulation was improper. And Mother has not articulated a reason why waiver doesn't apply. And even if this court finds that waiver does not apply, granting the motion to reopen evidence was not an abuse of discretion. This is a case where the trial judge was careful and thorough, and she explicitly asked for comment on her October 18, 2021 conditional order. Naturally, a trial court wants to hear all the relevant evidence, but that's especially true when a child's welfare is at issue. It was not an abuse of discretion to grant the motion to reopen in order to hear that evidence. Now, because Mother raised it in argument, I'll briefly address whether or not this was a final order. From the trial court's statements and actions, the October 18, 2021 order was clearly not a final order. First, if you look at the October 18, 2021 order, which is at Record Appendix 83 through 84, you'll see that the trial court made 5 findings: that Mother was unfit, that Father was unfit, that both parents' unfitness was likely to continue, that termination of the father's parental rights was in the best interest of the child, and that conditional custody of the child to her mother with DCF and court oversight was in the child's best interest. That 5th finding here is the only finding that DCF would have appealed, and is also the finding that the trial court explicitly stayed, stating the order of custody to the mother is stayed until November 23rd, 2023, pending a transition plan and comment on the court's conditional custody order. If there was any final order within that October 18, 2021 order, it was the termination of Father's parental rights. In fact, in the next paragraph, the court orders in all caps and bolded, the issuance of a decree dispensing with the need for the father's consent to or notice of any adoption, custody, guardianship, or any other disposition of the subject child named herein. It is at this point that the trial court in her order notes that the party's right to appeal shall run from the date of this notice of decision. The trial court also issued 2 notices of appellate rights at Record Appendix 85 and 86, and there's a notation in the docket at Record Appendix 14 that the notices of appellate rights apply to the father. Second, the fact that the court asked for comment, stayed the order more than 30 days, and granted DCF's motion to reopen evidence shows that the trial court did not view its October 18, 2021 order as a final order. I'll turn next to the issue of termination of parental rights. The trial court's ruling that Mother was unfit, that her unfitness was likely to continue into the indefinite future, and that termination of parental rights was in the best interest of the child is supported by clear and convincing evidence. The trial court's ruling is grounded in 374 largely undisputed factual findings, 24 pages of conclusions of law. I just want to mention a few examples of undisputed evidence. There was ample evidence of Mother's serious mental health issues, which caused paranoia, disorganized thinking, and a distorted view of reality that was evident during her trial testimony. There was also ample evidence of Mother's history of domestic violence, including her dishonesty regarding her relationships and her poor decision-making. Lastly, there was ample evidence of Mother's failure to attend parent-child visits and that mother's missed visits had a detrimental effect on the child. In her appeal, mother takes issue with certain specific findings of fact and argues that these specific findings are clearly erroneous. Because mother mentioned the relationship with Stephen, I'll address that briefly. Importantly, despite what mother has argued, the trial court was not focused on Stephen's murder conviction besides mentioning that fact. The trial court's findings were concerned with mother's behavior and her judgment regarding her romantic partners. Mother frequently lied to both DCF and her therapist about her relationships. And regardless, mother does not contest most of the factual findings regarding her dangerous romantic relationships, which included a violent relationship with her ex-husband, a violent relationship with the child's father, a relationship with a convicted sex offender, a violent relationship with a man who attacked mother in child's presence, and a relationship with a man that ended when he obtained a restraining order against mother. Second, even if mother is correct, which she is not, that there are some errors in any of the court's factual findings, it does not change the fact that there was ample undisputed evidence that terminating parental rights was in the child's best interest in this case. And I'll turn back to reasonable efforts just briefly. There are multiple issues with mother's arguments regarding reasonable efforts, including that she waived many of her arguments, failed to timely raise deficiencies with DCF's efforts, and that her arguments, even if true, wouldn't warrant reversal because it was still in the child's best interest to terminate parental rights. But this court need not address those issues because there was ample evidence in the record that DCF made reasonable efforts. And I'll address visitation last. Both mother and child appealed the trial court's post-termination visitation order, but there is no abuse of discretion for 3 reasons. First, the trial court properly weighed the evidence, both positive and negative, in considering whether post-adoption visitation was in the child's best interests. This included, for example, the significant relationship between mother and child, that their visits generally went well, that mother missed numerous visits, that the harmful effect mother's missed visits had on child, and that mother was inappropriate at times during visits. Second, mother and child's arguments are based on mischaracterizations of the visitation order. The order granted 2 visits, but that's a floor, not a ceiling. Nothing in the court's order prevents any amount of additional visitation that child's pre-adoptive parents determine is in her best interest. Third,
the department take the position that the mother is prohibited from responding to the child's correspondence?
She's absolutely not prohibited. It would be in the pre-adoptive parents' judgment of what's in the best interest of the child and whether or not to share any cards or anything sent by mother to the child. And in this case, there's no basis to question the presumption that the child's pre-adoptive parents will act in her best interest in evaluating, both now and in the future, whether more contact with mother would be in the child's best interest. Because there is no basis to find an abuse of discretion here, the trial court's decision should be upheld. And unless there's any further questions, I'll rest on my brief.
I don't think so. Nope, seeing none, thank you very much.
Thank you.
Thank you all very much. The panel is fully aware of how difficult these cases are, and we will give it our utmost attention and have a decision as soon as we can. Thank you very much. The court will take our 15-minute recess now. Thank you.
Hold on, rise, please. Court is now in recess.
All right, well, it's still morning. Good morning. I'll call the next case, which is 2023-1190, City of Taunton and another versus Jefferson Development Partners, LLC, and others.
Good morning. May it please the court. My name is David Hadass. I represent the appellant, LHPNJ. We are here because the court below erred as a matter of law in interpreting Chapter 148, Section 5 in an overly cramped manner, the result of which are that significant legitimate charges against a property owner will go unpaid under the court's ruling. That statute, Section 5, allows, the primary purpose of it is that it allows fire departments across the Commonwealth to enter buildings and other structures to abate any fire risks. It's not used often, but it is, this case is a perfect example of when fire risk is so significant that the fire department must take action.
Well, can I interrupt you for a second?
Yes, sure.
So I understand that if, in part, your argument is that the judge really erred as a matter of a factual matter by holding that there were 5 different segments of fire watch, where you say that that's not the case, right? So how does that really affect the interpretation of the statute? I mean, that's a factual issue, if I'm not mistaken.
I would disagree with that, Your Honor. The facts at issue are no one disputes. Firefighters were stationed at the property on certain dates. We have in the record literally a day-by-day accounting of that with the firefighter's name and the rate of pay and the date, et cetera. What the judge did was interpret Section 5 to say that under those factual circumstances that these were multiple fire watches rather than what the fire department viewed it as, which was one continuous fire watch with some interruptions or suspensions here and there as the facts on the ground dictated.
How would you differentiate a suspension of the fire watch from a termination of the fire watch? There must be instances in which you have multiple fire watches for a single property. What's the difference?
Well, I think in this instance, some deference should be accorded to the fire department, the people on the ground dealing with the situation. And one day may be different than the next day, as this case demonstrated. There were multiple times when the fire suppression systems and the fire alarms were repaired to such a degree that the fire department agreed to pull its people back, only to find out later upon an inspection that it actually wasn't fully repaired, or in one instance there was a fire.
Are you saying it's a question of law as to whether or not the fire watch was suspended and not a question of fact? In other words, the judge finds the facts, of course, as you know, right?
Yes.
So, and then you have other arguments that might prevail. So I don't want to spend too much time on this. But once the judge hears the evidence and heard the testimony from the appropriate people, and decides that there was an end point and a beginning point, how can we override that?
Because we believe that those conclusions on the part of the judge, and he, I believe he used that terminology, that he holds or he concludes. It wasn't a finding. It was more of a conclusion of law, and we believe that's what it was. The fire department is the one that, in the first instance, should make a decision as to its own actions, how to characterize its own actions. As I said, some deference should be accorded to the fire department. The idea that years later courts are going to examine old records and sort of rewrite history a little bit, especially in a in a case like this where the only reason to do that is to alleviate some debt from a mortgagee, which would.
Well, there's an issue, and there's a statute, and the land court is authorized and has responsibility to set the amount of the lien, right?
Correct.
So, I mean, we could quibble a little bit about rewriting of history. This is an obligation. An amount has to be set, right? And it's not necessarily what somebody thinks it should be. It's what that judge decides it should be based on evidence that's presented to him or her. So, I can understand your second and third argument that, for example, under other statutes, that these irregularities are not substantial, and so they should not have been considered, or the public policy argument. But I still am having a hard time understanding how we take the decision away from the judge about whether or not there were 5 segments or not, based on the fact that it was a legal conclusion, not factual. If you have anything else to add on that, I'll hear you. Otherwise, you might want to go on to your next arguments.
Yeah, I'll move on to Chapter 60, Section 37, which should take care of the concerns that you just expressed, Your Honor, because that statute basically says that non-material and non-misleading procedural errors should not lead to the voiding of tax debt.
And I presume your point is these are non-misleading because there was these weekly invoices that went to the at that point the landowner.
Sure. If you look at Section 5, if you sift through it, there's basically 3 procedural requirements that the fire department should follow. Number 1, inform the property owner by way of a written notice before you impose the fire watch. So the procedural error here was that when the fire watch started in 2011, and the property owner was fully aware of it, agreed to it, et cetera, but the written notice wasn't delivered until 4 days into the fire watch. So that's one procedural error that appellees point to. Second, that there was not at the end of each separate fire watch, to use the judge's framing of it, there was not an official accounting delivered to the property owner. There were weekly invoices. Whether they're called invoices or accountings, we fail to see any distinction between those. And the third procedural error cited by the judge was, again, if you take each segment as a separate fire watch, not all liens were filed with the Registry of Deeds within 90 days of the conclusion of each fire watch segment. It was at the end done, at the final end, but not done for each segment because, again, the fire department didn't view each segment as its own fire watch. Anyway, so Section 37 addresses procedural errors exactly like this, not material and not misleading, and appellees have not asserted that they were misled in any way. They are not the property owner, they are the mortgagee. To the extent that they want information about what's going on at the property, it's their obligation to talk to their debtor or be involved somehow at the property. Section 5 doesn't require the fire department to put anyone else on notice other than the property owner. In addition to Section 37, there are significant public policy issues that I'd like to speak about. We should backing up the lens a little bit. What we're dealing with here is a property owner that did not have fire suppression and fire alarm systems up to code, presented a significant danger, and the fire department was fully within its right. No one seriously disputes that, to do what it did. So the only question for this court is, does the property owner have to pay for it, or can it rely on, and I say it, but it's really its mortgagee, should it rely on some procedural errors that it located in the records?
Am I correct in understanding the record that there is no objection on the part of the landowner during this case to accept and to pay for the fire watch, except when, of course, there was a private firm that was hired after the bankruptcy proceeding started, right? In other words, there's nothing in the record that's going to say that there was any objection to what was the amounts, the weekly invoices, or anything like that?
No, and the property owner testified that he not only agreed to it, but that he agreed in concept that it was something that needed to be done, and that he didn't want the tenants who were in locations in the mill to be in danger. This is really opportunism, I would characterize it, on the part of a mortgagee to try to reduce legitimate debt. And of course, if amounts like this are not paid, that squeezes municipal budgets, that may lead to, in the future, fire departments not being as robust as was the case in Taunton in fulfilling their obligations. And it would also lead to a windfall, which is never in the public interest, in this case to the private party. Addressing the appellee, Wittenden's cross appeals, they argue that the tax title auction, by which my client obtained tax title, which they regret now, but they did it back in 2016, I believe, and have been in court over these past 8 years over it. But it was valid. The incorrect date on the website was of no moment because the municipality fulfilled its obligations by posting in the newspaper and at the library, so it checked all those boxes. And again, the Wittenden doesn't argue that it personally was misled. Again, this is going back in history, finding an error and saying this was misleading, therefore wipe these charges out. They were not misled. As far as their due process arguments, I would largely rely on the Attorney General's brief on that point, although I would add to it that anyone viewing this case, the fact that the parties have been in court for 8 years, multiple summary judgment motions brought by Wittenden, a trial on these issues, they've had all the process that is due. Finally, Your Honor, there's a question about the Supreme Court, the U.S. Supreme Court's recent decision in Tyler, and I know that counsel submitted a recently enacted state statute that would essentially codify Tyler. Those are weighty issues. All the more reason with the new statute to allow the land court and the parties to wrestle with it first. It's not something that the parties below dealt with, and the judge brushed it off as premature. If there are no further questions, I'll rest on my brief.
Thank you very much.
Good morning, Brian Hughes on behalf of the appellee, Winton Holdings, LLC. May it please the court, the findings of the land court in which they determined that there were 5 fire watches and not 1 or 2 or 3 should be upheld in this appeal because there's clearly findings of fact which are clearly supported by the evidence as cited by the land court judge, and they can't be overturned unless clearly erroneous. Here I think the evidence is pretty clear. The fire department officials testified as to the dates in which they were on site. Those are findings of fact. And going to Your Honor's questions as to, when is a suspension versus a termination, I believe in this case, when you have multiple, 2 gaps of well over 100 days, hundreds of days, I would suggest that that has to be determined to be a termination of that fire watch. When you go 249 days between February and December of 2014, that has to be seen as a termination. I believe if the land court found that the first 2 fire watches, or sorry, the second and third, were one continuous one, because there was only a week in between the 2, I believe the land court would have been justified in doing so. In this case, the judge did not. So I believe that those findings of fact should be upheld, and the majority, or the vast majority of the liens that were wiped out should remain that way. Further, the argument that Section 30...
Well, the liens were wiped out not because there's 5 segments, it's because of noncompliance with certain regulations, correct?
Yes, because if you break it up into 5 liens, the city didn't go through the 3 steps for each of those 5 liens. They did some steps for some steps for others.
But at all times, the landowner knew what was going on, correct?
Yes, the owner of the company, Jefferson Development Partners, was aware that there was a...
But why doesn't it render those other requirements in terms of a written notice instead of what was clearly upon occasion oral notice? I'm here because this is a problem. Here's what we're going to do now. Okay, great, do that. Here's your weekly bill for it. That kept coming again and again and again. Why wouldn't that be sufficient?
Because the statute is pretty clear. You have to render an accounting. And as a matter of law, I believe an accounting is after the services were rendered, after the abatement occurred. And frankly, the fire department never abated the hazard. It's still not abated. And so...
What is the purpose of that? What is the purpose of an abatement? It's to give notice of the amount, correct?
Well, the purpose of the account, yes, is to give them notice as to the final amount due. This is how much you owe.
And would you not agree that the landowner already had that information?
Yes, I believe the record is clear that Mr. Murphy had the information. But I would suggest that if we accept the land court's decision that there were multiple fire watches, my client was distinctly prejudiced because I also represented the previous mortgage holder. It's actually the same same parties. They just changed names.
Yeah.
So I've been involved in this since day one. And my client, in early 2013, went to the tax office, and it's in the record that he paid, I think, $172,000 in taxes and water liens and light liens. And he asked, I want to pay everything off. If the city followed the procedures, they would have already had 2, if not 3, recordings at the Registry of Deeds that would have put him on notice that there was hundreds of thousands of dollars owed to the fire department. So that's where we get to the prejudice of my particular client. I guess shame on the mortgage holder for the mortgagor to not keep my client fully informed, but he didn't make the attempt to pay it. And
Okay, so that's an interesting point. When you say shame on the mortgage holder, i.e. the landowner at the time, what was that? What was the obligation there?
Well, I believe any reasonable owner of property subject to mortgage should be keeping its mortgagee informed of a substantial issue such as this. But which is why my client went down there in 2013 to inspect the property, then went and paid off all the liens. He did his due diligence. He obtained an MLC in the fall that didn't have anything on it, and it wasn't until after that that the fire department allegedly certified the debt to the collector, and it became part of the tax title. We learned that at the record that we supports that was discovered during the foreclosure process. My client was trying to foreclose and exercise its rights, and the bankruptcy stopped it. Then we found this huge lien that was $260,000+. And so my client acted in reliance upon the information that the city gave it, and I believe that that is a distinct prejudice to him and his rights as a lien holder. The fact that time has passed is, not.
So, in your view, there's no obligation on your client at that time, knowing that the mill was in such disrepair. I mean, it wasn't a secret, apparently, that there was a real problem there, right?
Well, my client did not know that there was a fire watch on 24 hours a day. I believe during one time, it was during one of the gaps possibly, but I don't know how much of that is actually in the record, so I don't want to represent matters in the record. My client was never deposed and was not required to testify at trial.
Okay.
But moving on to the Section 37 argument, that statute says that an item added to a tax title shall not be deemed invalid for unless its error is substantial or misleading. First off, we have a situation here where we don't even have an item. The fire department failed to create a debt. So if you don't create the debt, that should never have been added to the tax title. And I believe that's what the land court was getting to in this case. It was never even, because they failed to follow the statute, there are 3 steps. The property owner did not even have an obligation to pay by statute. They could be sued for contract, I believe, but the city failed to establish the debt. So just by adding a bad debt to the tax title shouldn't cure that.
Well, how could that have worked? The owner would not have been able to do that because the landowner agreed to this and agreed to incur those expenses. So the landowner would not be able to turn around later and say, oh, you didn't actually create a debt. You gave me a weekly invoice, which I agreed to, but it should have been in a different form. How could that have been an appropriate argument?
Well, as stated in my brief, my client disputes whether or not there was an actual agreement here or just an acquiescence to a situation that cannot be undone. I don't believe Jefferson Development would have accepted the fire watch if it had an option not to do so. But there was no option not to do so under the statute and under the orders of the fire department. But even if there was consent here, my client is still suffering the prejudice by a wayward landlord, which the statute, if followed, would have prevented that.
Would have protected a mortgagee from this very fact.
Exactly. And I believe that failure to create the debt is a substantial error. It's not having a typographical error in a property description. It's more substantial. The debt goes to the fundamental collectability of the debt. And I believe the land court agreed with that, although I don't believe there are any trial findings on that. It was raised below in summary judgment findings. And further, going to the public policy argument, although I'm sympathetic to a municipality's desire and need to collect on its debts, the idea that the fire department is not going to protect the public because it's been burned for not following the statute before, I don't believe that would cause a public safety issue. I think that's overstating the case on that. So ask that, if the fire department did the basics of what it was supposed to do, we wouldn't be here today. And I don't think it's going to affect them going forward, Your Honor. Now, my brother did discuss the flawed tax title auction. And I know there's some question as to why does my client care who's collecting and who's not collecting. I believe in the Supreme Judicial Court's case in Talmadge, Lincoln, it made a clear distinction between a private property owner, a private owner of a tax title, trying to collect the full amount and not negotiating versus a municipality who has other interests. A municipality has interest in getting paid, but also interest in, in having the taxpayer come current and remain a taxpayer in the city. Here, LHP&J doesn't want the money. They want the property. So my client is being prejudiced by that because they won't have an opportunity to negotiate with a rational actor who would be willing to work with them on a payment plan or whatnot. So that's prejudicial as to what the tax title auction resulted in. It resulted in a party who had no interest other than a financial interest to take the property and develop it for a large profit. And further, Your Honor,
But you would agree that in those kinds of attacks, a title auction is permissible. Your issue is just that it didn't follow all of the appropriate rules. There was some misleading advertisement, et cetera, right?
yes, I believe that's it.
If that had been avoided, for example, then there would not have been a problem with having the auction initially.
Yes, the City of Taunton published notice online, the original tax title auction, didn't remove that when the date was changed and didn't publish a new notice. So anyone going back to see if there's a new notice would not have seen it. It was tacked on the bulletin board at the public library and City Hall and published in a newspaper 6 months later. So it wasn't like there was a continuation to a date certain. I specifically, it's in the record, requested the new date and was denied. And it came and went, and the only bidder was LHP&J. My client had an opportunity to either to bid or to solicit other people to bid.
Did you say did not?
Excuse me?
Did you say did not have the opportunity? I didn't quite hear you.
Yes, since my client did not know when the tax title auction was going forward, maybe it would have and maybe it would have bid, but at least I would have had the opportunity and maybe find investors it can work with who can bid in, as opposed to the appellant who is clearly a hostile actor towards my client. So there's an element of prejudice there that you can't prove because you can't prove what would have happened if things were different. But we can say that much like in a mortgage context or other sale contexts, defective notice, is fatal. And I believe that, the tax title auction should be unwound.
Were the first notices provided, out of curiosity, posted in the same places, the same Taunton Gazette, library, City Hall, and website?
So we're told. There's nothing in the record showing that there was actually posted on the at City Hall and the library, but I accept that the city did so. There's no reason for me to say it didn't happen. I didn't personally see it because I frankly, my client, but I had actual notice from the website and from working with municipal counsel's office. So with that, I think the tax title should be unwound, return this to the city, and now that we have all these new protections from the latest law that codified the Tyler case, I believe the city could absolutely receive payment for what it's due, and my client will not lose its equity because of a tax title foreclosure. So, and that being said, Your Honor, I know my time is running short. I did argue in my brief that I believe that the constitutionality of Section 5 is in question. There's no avenue to appeal or have review of any order of a fire department to remediate a situation that might cause fire. If the fire department charged $100,000 for 1 day's worth of fire watch, that's an extreme example, but there would still be no avenue to appeal. You can't file for cert. Declaratory judgment isn't available because you can't use declaratory judgment to appeal every municipal order. So I believe that the statute should be declared unconstitutional on its face. I rely heavily on the Reardon case because that's in the First Circuit, because it's so analogous to this. It has a lien that keeps increasing and the property owner can't do anything to stop it until years later, in this case, hundreds of thousands of dollars in interest. And I see my time is up, Your Honors. Unless you have any further questions, I'll rest on my brief.
Thank you both very much.
Thank you.
Appreciate your arguments. Let's get to our last case of the day here, 2023-1196, Emmanuel BRANDAO versus Boston Police Department.
Good afternoon, Your Honors. Brian Decker for Emmanuel BRANDAO. If it please the court, this is a rather straightforward case to the extent that there are no facts in dispute, and the legal issue is a narrow one. Mr. Brandao was hired as a Boston police officer he became a Boston police officer in June of 2017 after he had completed the Boston Police Academy. At the time that he became a Boston police officer, he was also a active duty military member, and during his one-year probationary period, he was called to active duty and did serve his country for 2 periods of time during the first year of his employment.
Which cut into his probationary period.
Sorry?
Which cut into his probationary period.
That's the question. Did it cut into his that's the issue, Your Honor, is whether he completed his probationary period, because on February 19th of 2019, he was placed on an administrative leave by the department, and he was subsequently terminated without being afforded the due process that's required by Chapter 31, Section 41 for employees who have completed their probationary period. It's our contention that he did complete his probationary period because the department never told him that they were tolling his probationary period.
But they did tell him when he graduated the academy that leaves of absence would not be credited towards his probationary period.
There is a reference in the very lengthy handbook that he was given in the academy, Your Honor. And you can see the reference. It's in the appendix. It's at page 43 of volume 1. It does mention very briefly that leaves of absence.
You told us at the beginning the facts aren't in dispute.
No, I agree that it's there, Your Honor. I'm just suggesting that it does not satisfy the requirement of notice that we contend that is required by Personnel Administrator Rule 12.2.
Well, Section 61 says that the probationary period of 12 months has to include actually performing the work of a police officer, which your client only did for 200 days.
Well, the court in the Cecil case does say that the probationary period must include the 365 days, well, they wouldn't all be on duty, but a year of actually performing the duties. What I'm suggesting is that Chapter 31, Section 61 also says that the probationary period will be 1 year except as otherwise provided by civil service rule. And the personnel administrator rules are the civil service rules promulgated by the HRDs.
Are you saying that an administrative rule can trump a statute?
No, Your Honor, I'm not saying that at all. What I'm saying is that the personnel administrator has interpreted the statute to require that an extension of a probationary period be identified by telling the person when you're extending it. The requirement that the idea that the courts have interpreted the probationary period to require actual performance of the duties is not in the statute. That's the court's interpretation, and I'm not disputing that that's what the SJC said in the Cecil case, the Boston v. Cecil or Cecil v. Boston. But what I'm suggesting is that there's an exemption that's created by the personnel administrator rule.
Well, that rule does not say what the effect of not giving notice is.
I agree, Your Honor.
But you think that, well, actually you wrote in your brief that it's compelled that we have to interpret it to mean that he doesn't have to do 365 days?
Well, I would say that the reasonable interpretation of the statement that, quote, written notice of such extension shall be given to the employee would be that if you don't give that notice, there should be a consequence. And in the Patterson case, the civil service, and that's the only Patterson v. Plymouth, the Civil Service Commission did interpret that the failure to give notice to a firefighter who...
Oh, you know, I've read Patterson a couple times, including again this morning, and it just doesn't say that. You're connecting dots that they do not connect. The commission does say that there was leave of absence, but when you get to the end of the decision, they say they fired him 2 days too late. They don't say it was improper because of his leave of absence being credited, should have been credited. They just don't say that.
But that was what happened. The fact that the leave of absence, they say that they didn't notify him, because he would have.
You're right. They do mention it, and they do mention paragraph 12.
Yeah.
But that's not the basis of their decision.
I think if you look at the way they interpret it, Your Honor, I would suggest that that's the conclusion, whether they stated it explicitly or not. That is the conclusion, because he otherwise would have been, if you exclude the month and a half in that case, then there wouldn't have been a question about it being too late.
See, the way I look at it, it's not so much a question of an extension as it is a question of an exception. And by that I mean Section 61 accepts leaves of absence from the calculable performance time of 12 months, regardless of what other exceptions what extensions may have been available.
I guess I would argue, Your Honor, that that's not what, Section 61 does not state that the interpretation of the court in the Cecil case, for the case in Cecil where the employee didn't reach a year because he was placed on administrative leave for misconduct, that in those cases, obviously, the court has spoken, and I would argue, alternatively here to the Rule 12.2, that where the leave here is for military service, which I would argue is similar to police service, the Cecil case.
He's not actually performing the duties of a Boston police officer when he's admirably serving our military.
Absolutely, Your Honor. That's correct.
So it's not actual performance of police duties.
He is not performing the duties of a police officer. He's performing the duties of a soldier.
The SJC says the idea for firefighters and police officers to have this 12-month period is that it gives it's a lengthy probationary period for the very purpose of seeing how they behave, the courage they have, the skills they have, and how they act under stress and pressure of the job. And 200 days is inadequate under the statute.
Your Honor, I understand that's how the Civil Service Commission ruled, and that's how the Superior Court found. I would suggest, again, that the Rule 12.2 creates an exemption.
Okay.
And I would just note that, the consequences here are whether or not he was entitled to a due process hearing prior to when he was terminated. We're not... I think the consequence of a ruling in our favor in this case would be that under Section 42 of Chapter 31, the action was inappropriate, but the police department would remain fully capable of, firing him again, if you will, based on the conduct which caused them to put him on leave in the first place. So this is not a suggestion that somehow he gets to skip out on the probationary period and gain some rights to engage.
No, we understand that. I'm speaking at least for myself, but and we can't second guess BPD's justification for termination. We can't put ourselves in the place and saying the firearm incident doesn't justify a termination. That's not before us.
Not at all, Your Honor. And I'm not suggesting that. I'm not suggesting, they very well
even if we disagreed.
Correct. And again, if all I'm suggesting is he had a right to due process before they did it.
Mm-hmm.
If there's no other questions, I rest on my brief.
Thank you.
Thank you, Your
Thank you.
Honors.
And good afternoon, Your Honors, and may it please the Court. James McGee on behalf of the Boston Police Department. We are here today asking that the Court affirm Judge Gordon's order finding that as the Civil Service Commission did, that it lacked subject matter jurisdiction to hear the appellant's appeal from his termination during his probationary period. While I would suggest this case certainly was Judge Gordon and the Civil Service Commission properly applying black letter law, I think 2 points bear further emphasis. As my brother stated, the facts really aren't in dispute here. The appellant only had served about 200 days of actually performing the duties as a Boston Police Department officer. And for that reason, he had not satisfied his statutorily mandated probationary period. Second, I would suggest that the appellant's reliance on Personnel Administrative Rule 12, as well as the Civil Service Commission's decision in Patterson, is misplaced. Certainly, this may be a closer case if the Civil Service Commission had come out the other way and said, Rule 12 requires notice, and if failure to give notice would result in crediting an employee with service such that they could get tenure, even if that service occurred somewhere else in the military. That didn't happen here. Certainly, I think the Civil Service Commission is entitled to deference under all of our case law surrounding administrative procedures.
Patterson is rather strange, though, don't you think?
It is rather strange. I think the Civil Service Commission did a nice job, Your Honor, distinguishing it from this case in their decision in this case. I believe they stated that it was a decision that was largely hinged on when the probation period started. And I do think that there's one significant distinguishing factor here, which is we actually have a finding from the Civil Service Commission that the appellant was on notice that time spent on leaves of absence wouldn't count.
They acknowledge the elephant in the room, but then they don't discuss it.
Correct. And I believe they said it in the decision in this case, too, that it wasn't the focus of their decision in that case.
I didn't find that helpful.
Fair enough, Your Honor. So I agree that there wasn't a robust discussion of what Personnel Administrative Rule 12, how it operates and what the remedy would be for a failure to give a absence-specific notice as to and I actually, the way I look at it, I wouldn't suggest it's actually a extension of a probationary period. It's notice that of the prospective date when one would complete the 12 months would occur. So I agree that in Patterson there's not a robust discussion about what the remedy is. Patterson's obviously a much different case because we were dealing with 2 days between.
But there's no discussion of what the remedy is. They say that they were 2 days late. They ignored the fact that Patterson was on a leave.
Correct. It was not fully addressed in that decision.
I understand why Mr. Brandao can argue that Patterson stands for the proposition that I get credit for the time I was on military leave because and it's not a direct connecting of the dots, but the dots are all there to draw a picture in his favor.
Fair enough, Your Honor. I do think that if we look at sort of the facts of Patterson, though, what the municipality should have done in Patterson, frankly, certainly they could have given him a notice saying your probationary period is extended by I believe it was 45 days you were on injury leave. But where Patterson's issues were actually performance related, I believe it was something about writing police reports or an inability to write police reports. What they should have done is noticed him under Section 34 saying, you've had a unsatisfactory performance review. For those reasons, we're extending your probationary period by 2 months. So that seems to be where the frustration of the Civil Service Commission in Patterson laid. But I agree that it was not fully addressed there as far as what the remedy would be.
Is this an outlier or in that BPD ordinarily gives notice under paragraph 12?
So I would certainly suggest we probably wouldn't be here right now if we had. I know that we do often when we place someone on administrative leave, give them a notice saying this time will not accrue. And it's certainly not part of the record here. Employees of the Boston Police Department are notified in changes in duty status through personnel orders. There are orders that are emailed department-wide if someone's suspended, is placed on injury leave, takes time off for any extended period of time, or goes on military leave. There's a personnel order that goes out to the department. This includes a notice to employees when folks graduate from the police academy saying the following people have been appointed probationary police officers, and there's a subsequent notice when folks finish their probationary period saying this person's being transferred from a probationary police officer to a fully tenured civil service police officer. So there's certainly different ways we notice people. I think certainly going forward, best practices would be to give absence-specific notices saying this is your prospective date that you would complete your probationary period. That didn't happen here. It wasn't the practice at the time. But I think if we're going to look at, to the extent, and I'm certainly not suggesting the court should get there, because I think, what the Civil Service Commission said is entitled to substantial deference.
No, we promised only to decide this case.
Fair enough, Your Honor. But to the extent the court was trying to craft a remedy saying, hey, this is what you should do when there's a failure to notice, I think the next step in that analysis would always have to be prejudice. There's certainly no evidence here that the appellant believed he was off probation and therefore engaged in off-duty conduct that led to his termination. I think he was fairly certain he was still on probation. There was no personnel order issued saying you're off probation. So I don't think that there's any real prejudice from a failure to notice here.
So I'm sorry, so that is ordinarily when probation is terminated, they get a written notice?
So an officer successfully completes their probationary period, yes, there's a email that would go out department-wide stating the following officers. It's usually with their graduating class from the police academy, maybe in 2 batches of people have taken leaves of absence or what have you. But there's a written notice that would go out saying the following probationary officers are now fully tenured civil service employees. They're also assigned to the police academy during their probationary period and detailed to districts, so they'd be transferred to a district at that time.
Okay.
And if there are no further questions, I will rest on my brief.
I see none. Thank you both very much for your arguments. We appreciate it. Okay, we've concluded our business for today. The court will stand in recess.